Thank you everyone for joining today's presentation in the IP Masterclass series brought to you by the SLW Institute. My name is Brian Ness, helping facilitate today's presentation. Before we begin, let's go down a few housekeeping items. If you have any questions during today's presentation, we encourage you to use either the Q&A or chat feature. Also, we'll be sending a follow-up email to each of you that provides a link to the recording and a copy of today's slides. For today's presentations, patent attorneys Kirt Iverson and Tim Singleton are going to bring you through how patentability for theoretical inventions have changed over time. They'll also compare practitioner strategies that have succeeded and failed with the USPTO since Alice decision, and also provide you with practical tips to consider in your practice, especially in light of the Berkheimer decision this past February. Kirt and Tim, I'll let you introduce yourselves and take it from here.
Hello, everybody. My name is Kirt Iverson. I'm a patent attorney here in Schwegman, Lundberg, and Woessner's San Jose office, and I'm with my colleague here, Tim Singleton, who's also in the San Jose office.
Hi, it's nice to get to talk to you all today.
Our outline is basically to go over some of the patent acts in the Supreme Court cases, the federal circuit cases, and then get to Berkheimer and how things have changed after Berkheimer. And then we'll go into some strategies for responding to one-on-one rejections and considering prosecution going forward in those cases, and tips for drafting, and then we'll try to take some questions. So how did we get here? That's the question we're going to start with. The Constitution says Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. So patentable subject matter, unpatentable subject matter. We know that anything that is not a discovery is unpatentable subject matter at this point. And right, I would also argue anything that does not promote the progress of science and the useful arts is unpatentable subject matter.
It's debatable, but so essentially we've got, as the Constitution does generally, is provide a framework for Congress, in which Congress can act. And although we start out with discoveries, which is a loaded term with a whole lot of potential patentable subject matter, Congress is going to quickly reduce this substantially. So when we look at our two examples, teleportation machine and a chainsaw, they're both a solid maybe patentable at this point, because we don't yet have the implementation of the framework or the general fence that the Constitution provides.
And they're patentable if Congress says they are, basically. And by the Constitution.
Right. So it's an open question until we get into the 1790 Patent Act.
Right. So the first three patent acts start to define what is patentable. And the statutory categories are useful art, manufacture, engine, machine, or device, or any improvement thereon in the 1790 statute. And that changes slightly in 1793, where they add the composition of matter.
Right. And then make sure to add that it's new, that it has to be new and useful art, machine, manufacture, instead of just a useful one.
Right. So anything outside of the enumerated categories is unpatentable.
Right. And when we look at the teleportation machine and the chainsaw, I think it's a solid yes, right? We've got a machine in both of these things. So under these first three patent acts, it's a solid yes on all of them. I think it's important to note, though, and we'll talk about this later on more, is that what we would now consider 112, 101, 102, 103 issues, all of these are combined in a relatively short space in these initial patent acts. So it's understandable that the patent act or the patent analysis is going to be sort of muddled or conflate things, required to dispense with multiple concepts in a sort of short shrift.
Right. So we get to the first U.S. precedential case dealing with subject matter eligibility that's cited in some of the modern decisions that we'll get to later. And this is where the idea comes about that there might be something that's not patentable, a judicial exception, even though it falls within the statutory categories. And examples are given of steam power, electricity, or any power in nature.
Right. So this is essentially but the problem with this case, right, is that all of this is dicta. This case really isn't a patent case so much as it's a jury instruction case, right? The judge initially gave improper jury instructions, telling the jury that what we've got here is a patent directed to a principle of a leaden pipe, which was clearly, if you read the patent and read the opinion, it's not what the patent was directed to on its face in the claims or in the specification. And so the court here is rolling this back and saying that's an improper jury written instruction, go back and do it properly. But in the process of doing that, it's providing an anchor, right? So it's bringing in English common law. It's bringing in this discussion of whether a principle is patentable or not, what may be a good or bad patent, in order to sort of provide an initial bulwark, because we hadn't had really any appreciable patent cases up to this point.
Right, and the only way you can consider this idea or this new judicial exception to be not dicta is if the jury could have made a decision, having been supplied with the correct jury instructions, that the subject matter that the patent at issue was not patentable because of its subject matter. And I don't think that was the question that was before the jury. I mean, if the jury had been given the correct instructions, they would just be deciding whether it was new,
right,
or useful,
right,
under the statute.
And subsequent judges, subsequent courts haven't treated it as a question of fact either.
Yes, and that plays into Berkheimer a little bit later too, as to what is a question of fact and what is a question of law. So we get to O'Reilly versus Morse, and here we have the idea of motive power with regard to a particular process with which it is connected in the patent being patentable, but when it's not connected, it's unpatentable.
Right. So essentially, this is the primary case that kicks this whole thing off. That we're starting from an understanding, or starting from an opinion, that a principle without an application is unpatentable. So long, you may have a principle involved in the claims, but so long as you have an application of it, then you're in patent eligible subject matter, and then we can move on from there, right?
Right, and I think that the unpatentable example that's given there about the claim that was not patentable, that had to do with the written description and whether or not all uses of electromagnetism had been described in the specification sufficiently to enable one to make one skilled in the art to make and use the invention. And the court determined that the specification just didn't support all uses of electromagnetism for marking and printing.
Right, exactly. But the issue is, and again, when we have a patent act that combines all of these elements or all of these aspects, right? The written description, the novelty, the patent eligibility, multiple aspects are going to come into play at the same time. But once we get to the 1952 Act and we separate that out, the court should be doing a better job at addressing separate questions. And unfortunately, as we know, they don't.
Okay, 1853, Corning versus Burnin. We now have this idea that, basically clarifies this idea that you can have a process completely independent of the machine that's patentable, and a patent on the machine also. And these are both patentable things.
Right, which is essentially just recognizing what is in the statute, right? That you have an art, which in this case would be the method or the process, and the manufacturer are both patent eligible categories.
Right, but then the court says, as an example, that the function itself of the machine, or all of the machines that may be invented to perform the same function, that's not patentable subject matter.
Right, and this raises the question, this is one of the initial questions, of whether this is an issue of preemption or an issue of like 112, right, enablement. And so I think I would assert that this is an issue this is a 112-ish issue, that you can't possibly describe all of those things, so you shouldn't be able to necessarily get a patent to all of it at the same time.
Right, but anything you do describe, any machine you do describe that performs the function, you should be able to get a patent. That is patentable subject matter.
Right, absolutely. But potentially the problem is courts are using this, or courts are sort of using this line of understanding with the preemption to do something that is not necessarily statutory.
Okay, the rubber tip pencil case. I love this case because we will see throughout all the modern decisions on subject matter eligibility this reference to an idea of itself. And it turns out this case was not decided on this dicta about an idea of itself.
Right, and so essentially what we've got a new device, or a patentable thing in this case, according to this judge, would be a new device by which an idea may be made practically useful. So when we dissect it, this is no different than the previous line and line of cases that continues after this for a little while. That if you've got a principle in and of itself, that's not patentable.
Right.
If you've
Okay.
got an application of a principle, then that is what is patentable.
So I have a pencil and I have a cavity at the end of the pencil and I jam it into this rubber and I rip it out and there's a piece of rubber attached to my pencil now because it's stuck in the cavity and it's applicable to, it's a useful application. I can now erase things using the end of my pencil. That's an application and therefore this is patentable subject matter. It wasn't new though. That was what the court decided. It wasn't new.
Right, and so, but the issue here is, I think, properly understood, an idea of itself is no different than a principle of itself. But the fact that the language changed, the fact that they used this different example, now opens the door to courts interpreting what they think an idea of itself could be and why it may or may not be patentable.
Right. So we get to Cochran versus Diener, and now we have a process, irrespective of the particular form of the instrumentalities used, is patentable subject matter. And this, I think, plays into the software, whether considerations of whether software is eligible or not for patenting. Sometimes the machine is the same machine, but we have a different process implemented on the machine. It shouldn't matter that that is a generic machine. It really shouldn't under Cochran versus Diener.
Right. So Cochran is essentially just reinforcing the previous understanding that a method or process is patentable, and it doesn't have to be inextricably linked to a machine if it can be performed by multiple different machines.
Yep. Taubman versus Proctor, 1880 now. They introduced this idea that an article that is transformed and reduced to a different state or thing is patentable, but a mere principle is not patentable.
Right. So again, we're just following along this clear and concise line of cases that if you've got a principle by itself, it's no good. If you've got an application of the principle, you're in patent eligible subject matter.
But again, we have what may be dicta about a process encompassing every mode of accomplishing this result is not patentable.
Right. And so it's important to, again, in 1880, the Patent Act was still conflated these things into a single paragraph. And so we're going to have some of this bleed over from different tests or different aspects of the overarching question of whether a patent should be granted in any specific instance. But where in 1952, where we finally divide that out, and we should start getting clarity between the different elements of the total patent question.
And again, this is probably an enablement or written description issue, because
exactly.
If you describe the process or multiple processes or almost all the processes or all the processes, you're entitled to in a patent. I mean, that's patent eligible material.
Right.
Okay, telephone cases now, 1888. All uses of electricity are for uses, all telephonic uses of electricity is not patentable. But if you have something connected to the patent as a description and the use of magnetism, for example, that is patentable.
Right. And so again, we're touching on issues of enablement, possibly preemption, as the courts will go hog wild with later. But again, the fundamental principle here is that the fundamental idea here is that you've got a principle and you've got a concrete application of that principle. And so that concrete application is patentable.
Okay, McKay Company versus Radio Corp. This is a radio antenna. It applies a scientific truth, and therefore it is an application and it is patentable subject matter.
Right, and so we've got a slight clarification of this, of the idea of principle versus application of the principle, where we're the court's essentially clarifying that it doesn't have to just be a machine. It doesn't have to just be an active thing. It can be a structure. It can be an application of a principle, and so there's a slight clarification. But again, it's solidly statutorily based and solidly based on that same line of cases that we've got back from the beginning.
Right. Then we get to Funk Brothers, 1948. A discovery of the qualities of non-inhibition of certain species of bacteria, this discovery is not patentable, and it's considered a hitherto unknown phenomenon of nature.
Right, and so this does touch on a slight tension, but it doesn't turn out to be at least that compelling in later decisions. But a slight tension between what is patentable, at least theoretically constitutionally, with any discovery, and what is patentable under the Patent Act. But again, the primary point of this case, I think, or the primary issue with this case, is in its clarification. This is 1948. The next Patent Act comes out in 1952, and this is clarifying that application has to be new and has to have a new and useful end. Right. So we're integrating. So we're now more explicitly integrating this question of new and useful. So 102, 103 issues, just before we separate those things out into different areas.
Right. So we get to the 1952 Patent Act, which doesn't change anything really about patentable subject matter, other than it changes useful arts to process, which it was known to be already.
Right. But it does, and importantly, it does separate out 101 and 102, 103 considerations into separate elements of the total question of whether this invention should be patentable, or should have received a patent. But as we're going to see, courts haven't then broken out the analysis. They're still conflating the things, as we all know.
Right, and so we look at our examples, teleportation machine and chainsaw. I'd say they are still clearly patentable, even in view of these evolving judicially recognized exceptions to the statutory categories.
Right, because up until this point, a teleportation machine is still a machine, same as a chainsaw. It's still an application of, even if you find a principle, a natural law principle like Einstein's equation, it's still an application of it. It's still a machine-based application, and so we should be patent eligible, or we are, I would say.
Okay, so now we start to get into some trouble, because these are the first computer-related inventions that are struck down under the abstract idea judicial exception. First is Benson, where we have the conversion of binary numerals to decimal. And this is where the court says a mathematical formula or an algorithm itself is unpatentable because it's like a law of nature.
Right, and here's where we start. The famous the slippery slope argument. But here's where we actually get on the ski slope, at least with computers, is that the court is presented. In fairness, the court is presented with a sort of a difficult situation, because they've got a mathematical formula, right? So the patent is really essentially breaking down this mathematical formula into method steps, order of operations style, breaking these things down into method steps. And so the court is dealing with a fringe issue where the application or this claimed application of the principle is not that much different than just the principle itself, than just the formula. And so how does the court deal with that? Poorly. That's how.
And they start asking Congress for help at this point. They are saying that they can't determine, when it comes to computer programs, what's eligible and what's not, and they're asking for Congress to help. And that comes up again in Fluke. They again ask Congress to help, and this is where there is more of an application. We're talking about adjusting an alarm limit based on a formula. So there's an actual application, I would say, of this formula, but they determined that it's just token post-solution components that are being added to the claim, and it's still just an idea of itself, a mathematical formula, or directed to a mathematical formula, and therefore unpatentable.
Right, and so the issue is here. Fluke is so important in this context, or in this line of cases, because Fluke is where we finally have a hard separate bifurcation of the claim. So now we understand that there's possible to have a principle and possible to have a solution in that same claim, or possible to have an application in that same claim. But sometimes that application isn't going to be enough, as it had always been up to this point. An application was enough to get you patent eligibility, but if may not be new. But now we're starting to see the break and see some questions going on.
Right, and then things start to seem to get more under control with Chakrabarti, because
of course, correct.
Yes, the court says, okay, we look at the congressional intent behind the statute 1952 Patent Act. They meant for anything under the sun that is made by man to be patentable. However, there still are these judicial exceptions that have evolved, laws of nature, physical phenomena, and abstract ideas. But they start giving some examples of what these would be. So you have a new mineral discovered in the earth, or a new plant found in the wild. Einstein's law that E equals mc squared, or Newton's law of gravity. These are examples of things that are unpatentable under the judicial exceptions.
Right. So based on these examples that they've given, I think it's easy to, or I think arguably it's properly understood, the law of nature, the physical phenomenon, are obviously principles, right? And if you have an application of the principle, as with the old line of cases, you're good. And here, abstract idea, I think properly understood, is again an idea without an application, same as a principle. If you have an idea without an application, it's again not patent eligible. The application of it is what would be eligible.
Now consider your generic software application running on your iPhone. That is under the sun, and it's made by man. It's patentable subject matter, correct?
Right, and it's an application. It's not merely an idea. This reduction to practice of this application on your phone that you can interact with, or that you can, and that interaction doesn't have to be, reading it. Reading the display could be the interaction, but the application of it, the reduction to practice, should put it into patent eligible subject land.
And these are called applications, after all. They are applications of an idea.
Right. Surely that should be enough for the court, right?
Yep. So we get to Diamond versus Deere, and here's the first positive determination as to what constitutes patentable subject matter in the computer realm, where they determined that this particular application is sufficient for the claim to be directed to patentable subject matter, this curing of rubber using a mathematical formula, even though the claim includes a mathematical expression.
Right, and so it seems as though they've gotten back on track here, right? They're again what they've identified as unpatentable with the scientific truth that the mathematical expression of it is just simply this is something without an application. But the application, and they call it out, the application of a law of nature or mathematical formula, then we've got patent eligible subject matter.
Right.
Unfortunately, it doesn't stay on track.
Right. So now we run into Bilski, and this is where we get way off track. In this case, they determined that a method for hedging against the financial risk of price fluctuations is just unpatentable subject matter. How did they get to this result?
Right. So the issue here, I think the problem is the Supreme Court has a problem with fringe cases or with cases that are on the line, and they tend to react badly to them. So in fairness to the court, the claims in Bilski are talking about initiating a series of transactions, identifying market participants for a commodity with counter risk proposition, and initiating a series of transactions between commodity providers and market participants. So you've got essentially this wordy but fairly short 3-element claim, and the court's having a problem figuring out, is this just an idea, or is this an application of the idea? And I think they should have come down with it's an application of the idea, but it's an old idea. And so they should have, that 101 grounds should have been, it wasn't the best claim, but 101 grounds should have come down with patent eligibility, but then it be decided under 102, 103 grounds. And they had the basis to do this under the 1952 Patent Act, but then didn't.
Right, and again, they're asking Congress for help. They're saying,
right,
look, we don't know where the line should be drawn with computer programs as to what is patentable, what's eligible for patenting, and what's not.
Right, and so they're asking Congress to do something to help them out. And Congress does something.
Yeah, so the 2011 AIA comes, and there's no change at all to what is declared to be patent eligible subject matter under the statute. And there's no comment on the enumerated judicial exceptions either.
Right. Right. So as is often the case, you ask Congress to do something, they do something, but just not what you wanted them to do. Like my children in the morning, go get dressed. Well, sort of. Exactly. So, but the important issue there, that with the AIA is now this is an open question, not just what is appropriate, but whether Congress is accepting what the courts are doing, whether they're ignoring it, or whether they're just blissfully unaware. And so under the AIA, the teleportation machine, under the terms of the statutes, the teleportation machine is good. It's still a machine, and it's still a new and useful machine. Same with the chainsaw, right? So, or at least as far as patent eligibility goes, right? It may be found not to be new, but at least it's a machine, it's a useful machine, that sort of thing.
Right, and it's not a it doesn't deal with a financial transaction either, which is
Right.
now where the abstract idea has been expanded out to include financial transactions, apparently.
Right. And so the exceptions up to this point haven't sort of they've begun to bleed over into the "are you kidding me" sort of area, but they're not quite there. Get there right quick after this.
Exactly. So we get to Mayo, and now we've got a new definition of what's patentable and unpatentable, according to the court. You need several unconventional steps that confine the claims to a particular useful application of a principle in order to find patentable subject matter.
Right. And the painful importance of Mayo is that prior to this, really what we're looking for is an application, a clear application, right, of a principle. And if you've got a clear application, we're good, right? Because that moves us past Bilski and past the other, past Gottschalk or Benson.
Right.
But
And then-
now with Mayo, if the claims, so they have this application, but if it's not an unconventional application, if it's not enough, then it doesn't matter that you have an application of the principle, you're unpatentable.
Right. And so it's the wording about if the claim adds nothing specific other than what was previously well understood, routine, conventional activity comes into play. And we'll see this again in Berkheimer.
Right, and a painful conflation of 101, 102, and 103, and you know we're not the first to introduce this concept. This is a well-oiled groove at this point that people are seeing what Mayo and Alice and the CFC decisions that we'll touch on later are conflating these things after Congress has already separated them out.
Yep. So now we get to the current state of the law today, and that's the Alice decision, where now we have a two-step process to determine whether a claim is eligible for patenting or not. First is it directed to an ineligible concept? And two, if it is there a combination or an element or a combination of elements that is sufficient to ensure that the patent in practice amounts to significantly more than a patent upon the ineligible concept itself?
Right. So that initial that dipping the toe in the water with the previous cases, where the courts start to bifurcate the claims into the principle versus the application. Is the application new and useful? Now we're whole hog into subjective aspects as to it's not just enough to have a useful application or a new application, but even if it's new, even if it's useful, it may not be sufficient. It may not be significantly more, which is entirely subjective.
Right. And now abstract idea includes, according to Bilski and Alice, the fundamental economic practice long prevalent in our system of commerce.
Right. Which should easily be couched under it's old. So so you may be eligible, but it's old, and so you don't get a patent. It seems an easy decision to make.
So now what has the Court of Appeals done with the new rule under Alice? And this is going to be very frustrating.
Right. The court has done a lot.
So just looking at a summary of the lower court decisions, we have 104 decisions that the Patent Office considers to be relevant with respect to determinations of subject matter eligibility. Only 6 give us a positive determination at Mayo Step 1, and only 7 give us a positive determination at Step 2. All the other cases are non-precedential, or they included a negative determination regarding patent eligibility. And now the Patent Office has also taken the step in its materials to organize these cases into these categories that were alluded to in Alice about categories of allegedly unpatentable ideas. And we'll talk a little bit about that later, but these categories don't really match up to the precedents we've discussed up to this point.
Right, especially with respect to that last bullet point, the quick reference sheet, as we'll discuss in the application of these ideas later, is that the quick reference sheet really does cause some problems that it was arguably meant to solve.
Right.
And that with examiners using it or relying on it alone.
Yeah, and so we're going to talk about only these positive cases because there are a lot of other ones out there that you as a practitioner will have to differentiate from. But we want to just touch on each of these positive ones quickly.
Right, and we'll do it quickly because we understand that you've seen these cases before and are working with them today even probably.
Right. So the Mayo Step 1 test, it turns out there is not a test. There's no definitive rule to determine what constitutes an abstract idea according to the Supreme Court. So what the Supreme Court has done and what the Federal Circuit is doing now is comparing claims at issue to claims already found to be directed to an abstract idea or not in previous cases. That's the only way the determination under Mayo Step 1 can be made.
Right. And apparently the irony is lost on them that their test for an abstract idea is abstract in and of itself, which
Exactly.
is sad.
So now for computer-related inventions, the Federal Circuit has stepped in and they have a new rule now. And the rule is whether the claims are directed to a specific improvement in the capabilities of computing devices or instead a process that qualifies it as an abstract idea for which computers are invoked merely as a tool.
Right. So the easiest way to understand this is what should be under step 1, what should be patent eligible is a modification to the tool. Right. So if you have a screwdriver and you make some modification to the tool, then that should be eligible under step 1. But if you're merely doing a new use of the tool, then that we move into step 2.
And part of the problem with the Federal Circuit's test is that we have on one end improvements to the capabilities of a computing device, and on the other end something that's just that's invoking the computer merely as a tool, but we don't know what's in the middle there. Almost everything that we talk about is in the middle. It's not clearly one or the other, so it's just still a very vague determination that's being made at step 1, even under the CAFC's test.
All right, so now we'll move on to InFishing in 2016, and this is the first one that we have under step 1 that's patent eligible with a self-referential table for a computer database. And I think this is pretty clearly it's changing the tool itself. It's changing the tool itself of the computer, and
but
that's why.
I would argue, though, that it is software, though. It's not changing the machinery. It's a table that's implemented in memory.
Right. But the argument of the court, and I think maybe partly because they didn't understand how generally databases work, but that it is making a sort of low-level fundamental change as opposed to just an ornamental change, and that seems to be what they're relying on. Right.
But I've had examiners tell me that, oh, you're not changing a database table, therefore you're not patentable under InFish, or you're directed to unpatentable subject matter. Well, that's just one example of something that's non-abstract under the CAFC's test. There's a lot of other things. And I mean, that's the argument you make in response to that.
Right.
Okay, so then the second case was McRow. And this case was really about the preemption issue. The court made a decision at step 1 that the invention was directed to patentable subject matter because the steps used to produce this realistic lip synchronization did not preempt other ways of doing the same thing, and therefore they made it a non-abstractness determination at Mayo Step 1 for this case.
Right. So if you remember those earlier cases where they're dabbling in maybe preemption, maybe 112 sort of aspect, here we have an explicit attempt to examine and to use the preemption side of that, but that doesn't pan out as much in later opinions.
Yep. So Thales, this is where there are sensors in the claims, a particular configuration of sensors, and the court determines that this is a non-abstract idea. The improved method of utilizing inertial sensors to determine position and orientation of an object on a moving platform, that's just non-abstract.
Right, and I think and the issue is it's not just sensors, right? Because there are other cases, electric power for one, that incorporate sensors into the claims or incorporate sensors into the conceptual aspect of the claim. But here I think we've got something that as we'll talk about later, the judges are look at and say, oh, that's pretty neat, that's pretty technical. And so it's the placement and the use of the sensor that's important to the court here. And that
right. And then visual memory is kind of along the same lines because it's talking about the programmable operation characteristics defined by the processor and how the improved memory system works with that. And so it's like a deeper technical level than probably many of the things that the court has seen before. And that seems to be helping with this Mayo Step 1 determination. Moving on to the last two cases here, FinJan. So a behavior-based virus scanning method is not abstract. Now this is purely software, if I'm not mistaken.
Right. Right. And the issue here, and I think the differentiation is because again, this is arguably making a modification to the tool of the computer.
Right. There's a file there's a new kind of file.
Right, but again, this is a kind of even by the Federal Circuit's own sort of idealized test. This is a questionable as to whether it would fall under the first or second step, I think.
Right, and then the last case here is Core Wireless, where now we have an application summary window is not abstract. It has specific characteristics associated with it, but to me, this indicates that almost all user interfaces are not abstract. That's how I would interpret this case.
And then we get into Core Wireless, and Core Wireless is beneficial, and we've both used this to some solidly good use with patent examiners.
Yep. So let's move on to step 2, the cases that help us here. Alice kind of lays out what is not sufficient to transform the nature of the claims into a patent eligible application. So simply stating the judicial exception and adding the words apply it, appending conventional steps specified at a high level of generality, or reciting computer functions that are well understood routine and conventional activities, which comes again into play in Berkheimer. Also simply introducing a computer into the claims or claiming a process that could be carried out in existing computers long in use, or simply reciting an implementation of a mathematical principle on a physical machine. So these are the things that are not sufficient. But we move on to a couple things that the court has identified as being sufficient. One is reciting a new and useful application of the alleged judicial exception. Of course, this conflates 102 and 103 analysis with the subject matter eligibility determination at Mayo Step 2. And then the other one is the DEER example, where you've recited a solution to a technological problem in conventional industry practice. And the cases that help us here, or the positive cases, actually go back before Mayo. In its instructional materials, the Patent Office refers to 2 cases here before Mayo that are indicate what transformative elements might be in particular cases. For example, in the ABLE case, we have an algorithm for improving a CAT scan process. That was considered to be abstract, an abstract idea. However, it was transformed by the fact that the variables were defined in the claim for the algorithm, and the algorithm was placed in a particular relationship to a series of steps to which it could be applied. And those were the transformative elements there. In Surf Tech, the transformative element was a GPS receiver that was integral to the claims. And just having the presence of that within the claim transformed this abstract idea into a patentable idea. Here we have Klassen, where, and actually in this case, 2 out of 3 were found to be, independent claims were found to be unpatentable because they were directed to a familiar process that a doctor could perform in his head. But the third one was patentable subject matter because it included a further act of immunization.
Right. Human activity is apparently a transformative element, according to the court.
Right. We have transformed host cells in Myriad were considered to be patent eligible. It turned the idea of comparing 2 host cells, the abstract idea of comparing 2 host cells, into a patentable idea because they were man-made, as in Chakrabarti, those transformed host cells. Okay, DDR holdings. Now we're getting to the computer-related cases again, where we've got a specific way to automate the creation of a composite web page, and that was sufficient to take this possibly abstract idea. The court did not determine that it was actually abstract, but the possibly abstract idea of increasing sales by making 2 web pages look the same, that was transformed because of the specificity of the claim and the way that the page was created. And then finally, I think we have one more. This Bascom, the abstract idea was filtering internet content, but reciting a specific location for the filtering system and giving users the ability to customize the filtering for their individual network accounts was considered transformative and made this abstract idea patent eligible with the application. And finally, Amdocs, which is probably my favorite case, one that I cite often in my office action responses. The possibly abstract idea of correlating 2 network accounting records to enhance the first record was transformed into a patent eligible idea because it was a the claims included a technological solution to a technological problem. And this involved the distributed architecture and the distributed manner in which the correlation was performed.
Right. Now, Amdocs takes on a different significance, as we'll talk about in practice,
Yep.
where it's not just the finding of Amdocs that's important to responding to Alice rejections, but it's the way that the court constructed the opinion, where they compare it to negative and positive cases.
Yep.
And they specifically talk about the technical solution, technical problem. And these are things that we can leverage in responses in order to push the examiner to taking a more specific stance, and then push them to responding, coming on the record with a response to what, we hesitate to do, which is take an affirmative position.
Yep. Okay, so finally we get to Berkheimer, the subject
What
matter.
you've all been waiting for.
Exactly. So this is the case where the Federal Circuit has determined that the question of whether certain claim limitations represent well-understood routine or conventional activity, if raised as a disputed factual issue, precludes summary judgment that all the claims are not patent eligible. So Berkheimer is important for many reasons, but one of which, to me, is the fact that they apparently correctly applied the Alice precedent by looking at each individual claim at Mayo Step 1 and at Mayo Step 2, including independent and dependent claims separately, arriving at a different conclusion as to what the claims were directed to at Mayo Step 1 for each claim, and whether the additional elements in each claim amounted to significantly more than that identified abstract idea.
Right, but the practical effect of Berkheimer seems to be that now we're being provided some ability to require, as the USPTO put out their change in the guidance, to require examiners to take some steps at justifying why something is routine and conventional and well understood or not.
Right. And Berkheimer gives us some drafting tips, results in some drafting tips that we'll discuss later, but the claims that were held to be to have a disputed factual issue around whether they were well understood, routine, or conventional were the ones that were tied to the specification where it was described as being unconventional or improving steps to the invention. The claims that did not recite limitations that were explicitly recited as being unconventional or an improvement were held to be unpatentable subject matter.
Right, and one last touch on Berkheimer is this. No, the next slide is that question of the CFC recently decided to not rehear Berkheimer in bank.
Yes.
Or in bank. So we've got essentially we've got in the concurring opinion, which would be nice to be in the majority opinion, but we've got laying out some of these concepts that we've been talking about with laws of nature and what the Supreme Court has done, and now this response of requiring something, some actual analysis.
Right. And so Judge Laurie, in his concurring opinion, mentioned that the Supreme Court whittled away at the 101 statute in Mayo by analyzing abstract ideas and natural phenomenon with a two-step test, including looking for an inventive concept at step 2, thereby bringing aspects of 102 and 103 into the eligibility analysis. And so he talks about how we're now bringing the multi-step consideration of inventiveness back into the discussion of subject matter eligibility, where the 1952 Act was meant to solve that problem of inventiveness being a consideration.
All right, so now I think we can hop into the last couple of sections of what do we, now that we have the context, now that we have all of these cases, what do we actually do when the examiner issues a one-on-one rejection?
Right. So let's get into that.
Insult them. That's what we should do. No, I'm kidding. Obviously not. But there are several steps, right? Understandably, there's arguing on the prima facie aspect of it and arguing on grounds, and the issue that we have is sometimes it has been useful, but often not, to push that hard on the prima facie end. But Berkheimer may be changing that at least slightly. Right.
So the first thing that Berkheimer changed is now the guidance says that any assertion by the examiner that an element is well understood, routine, or conventional must be supported by evidence. So that's when we're trying to challenge the examiner's prima facie case. If there's no evidence, one of the 4 particular pieces of evidence that the office requires, if that hasn't been provided by the examiner, that's an immediate challenge right there to the prima facie case. And then going back to earlier before Berkheimer, we already had many things we could challenge the examiner on in terms of the prima facie case. For example, we know under the law that you cannot determine whether something is abstract or not unless you compare it, the idea, the concept at issue, to other cases that have been determined to be patent eligible or not. And many times the examiner will not do a comparison, or they won't explain the comparison. And the guidance specifically indicates that you must explain the comparison and the correspondence.
Right. Now, the level of explanation in the comparison, as we know, is oftentimes not that great. And what the PTAB does, what the PTAB is expecting from examiners in that explaining why element is regrettably sometimes not as much as we'd like to see. But the important takeaway on the prima facie case, I believe, and Kirt may have a slightly different take, but is to get the examiner to cite a case that he's comparing it to, not just the quick reference sheet, not just a category, but an actual case, because that's where you can get down to and then arguably drop the prima facie case argument.
Yeah.
Because that's where you can get down to the nitty gritty of why their comparison doesn't work, and why, based on the Amdocs model, why the comparison to a patent, either a case that was allowable under or eligible under step 1 or step 2 is a closer or better case to make the comparison.
Right, and I think you have to divide out, as we'll kind of talk about more later, but I think you need to separate your analysis at each step between Mayo step 1 and Mayo step 2, because there's different things that are required of the examiner at each stage. At Mayo step 2, for example, they have to identify any additional elements and explain why they do not add significantly more to this identified exception at Mayo step 1. And I've seen that examiners don't do that often. And it's something we should challenge, I think. Even though it may not be that effective of a challenge in many cases, I think it has to be an issue that's raised, especially in an appeal brief before the board, for example.
Right. So we've got a question from Ken, which is asking if we should just push the examiner to cite a case, or push the examiner to explain why facts of the case are the same or similar to claims under consideration. And that's the first battle, at least up until this point, was getting them to cite a case, period. Yeah,
that's the prima facie case element. I think you're getting more into the substantive analysis when you start explaining why the facts of the case are the same or not.
Right. And so the issue is they need to have cited a case first, and that's oftentimes the first battle. They're getting better at it, thank goodness. But now moving into the second part of that response is trying to force them to explain why.
Yeah.
We've encountered some difficulty with that because they seem to want to hand wave their way into the explanation of, well, because I said it's comparable. And so it's partly incumbent on us to accept that, unfortunately, that they're not going to do oftentimes a quality job of explanation, but to provide an explanation, positively or affirmatively cite our own positive case, and provide the explanation why the facts and why the claims are more like the positive case than not.
Yeah, but that's the substantive analysis, which we'll get to a little bit later. But at the prima facie case level, there are certain things that they need to do, and one of is explain why the concept corresponds to a concept in one of the negative decisions or whatever that they're citing to, and they often don't do that. It's an issue to raise, but it's not at the prima facie stage. But it's not that effectively found so far.
Right, and in the PTAB, the PTAB has oftentimes a fairly low bar.
Yes, exactly. Okay, so then, of course, we definitely challenge anything that's not supported with evidence, or any assertion that an identified additional element is well understood, routine, or conventional, whenever that's not supported in writing with one of the following pieces of evidence. And it's very specific in the guidance as to what the examiner must provide if they're making any kind of one of these assertions. And that, I think this is a challenge you definitely make at the prima facie case stage. So the next thing that examiners are instructed to do is come up with their broadest reasonable interpretation of the claims. And I think we need to challenge this often, because this is where the battle is going to be fought, I think, is how you characterize or delineate the claim between the abstract idea and the things that, the additional elements that could constitute significantly more than the abstract idea. And I found that an examiner will often group every element into just what he calls the abstract idea and identify no additional elements. And that is a completely unreasonable interpretation in most cases, in my opinion. The court has given us some guidance as to what is reasonable with respect to a broadest reasonable interpretation that's made by the examiners. And so Alice, for example, says that when the examiner simply asks whether the claims involve patent ineligible concept, that's not sufficient. It's whether the claims are directed to that concept. When the examiner fails to consider the claims as a whole, and this comes up quite often, actually, where the examiner will break the claim up into different elements and claim that each different element is directed to a different abstract idea, and that's not looking at the claim as a whole. That's just incorrect.
Right, and this is actually a good time to chime in. Mike provided a comment that said the examiners often don't read cases, and that's absolutely true. I've spoken with a number of them that plainly had not read the case or understood what was going on, but rather either referred to the training materials or worse, just the quick reference sheet. And he suggests, and this is something that we've done in practice, of having stock arguments to address the cases, especially the ones that are kind of disfavored or not generally cited or are oddballs.
Right.
And that's one of the things we often do, because oftentimes they're easy to sort of get rid of, or at least to set up that argument, and then to incorporate fact specific or claim specific aspects appended to that argument or added onto that argument. So that's definitely something we do, and use that basic sort of generated a basic template and use that as a toolbox, essentially, to pick and choose what's appropriate for the case, and then to add on and flesh out to save time and to save effort, because, you know, as we all know, budget is always a consideration.
Yeah, and Ken asks, is there any guidance in the new MPEP as to how the examiner is supposed to slice and dice the elements to define the idea versus the supporting elements? No, other than they are challenged, or they must provide their broadest reasonable interpretation of the claim. And we've actually thought about this as a firm. We are thinking of providing some comments to the Berkheimer guidance. I guess there's open comment period right now, where we suggest that we need to address this issue of how the examiner slices and dices the claims. I mean, this is critical to the determination. And I think it's where really the battle is in most of the cases. Because now, think of this. If we can get an examiner to admit, or if we can agree with an examiner, not just get him to admit it, but if we can agree with an examiner that certain elements of the claim are not part of the abstract idea, but are the additional elements, well, now under Berkheimer, he must provide evidence that they're well understood, routine, or conventional. Otherwise, we should prevail at Mayo Step 2. So things that constitute additional elements that go beyond the judicial exception, it's the search for the inventive concept. This is where I think the examiners are being unreasonable when they say there's no additional elements in a claim, because they've obviously, in many cases, not engaged in any kind of an analysis that can be described as a search for an inventive concept. If an examiner is always concluding that every element of the claim is just the abstract idea itself, and there's nothing additional, other than what they'll often do is say it includes a processor, or it includes modules, or something that's generic, and refer to the specification as supporting the fact that it's generic or something. And those are the only additional elements that they define. Well, they haven't done the correct analysis, because that's not how you search for an inventive concept. And the case law, including Berkheimer, talks about it has to be how, one of the considerations is how the abstract idea is implemented. Are they looking at how it's implemented as part of their analysis? If not, it's not a reasonable interpretation.
Right, and the issue that Ken brings up with the question of the more elements you can consider as defining the inventive concept, the less likely the examiner is to be able to identify or analogize accurately to previously decided cases is true. But
Yes.
But the issue here is that effectively the examiners are. In my experience, it is rare that examiners are properly analogizing, properly arguing the cases that they have, and so that's part of the issue, and that's why I've come to this conclusion, or generally come to this practice, and have gotten, and most of the time that I've overcome an Alice rejection, especially in 3600, which I got a couple back fairly recently, is my affirmative arguments comparing to core wireless and lining up the claims, comparing, unfortunately, comparing elements and comparing discussions by the court and proactively doing it. So the most of my allowances haven't been necessarily because I've dismantled an examiner's argument, because those aren't terribly difficult to do, but it's because I've had to take the step of proactively comparing to a positive case and gotten the examiner to come along that ride with me.
Right. And I have an example of a case where I had a multi-step process of displaying a user interface within a game that was a secondary user interface, and terminating it and presenting it under certain conditions that were all recited in the claim. And the examiner concluded that my claim was directed to managing a game. And there were no additional elements at all. It was just managing a game. And the board upheld his 101 rejection. It was the most absurd thing I've ever seen. And I'm now preparing a request for rehearing in this case. But how can you boil down all these elements that I've specifically recited into the idea of managing a game when my claim did not even recite managing a game anywhere in there? It did have a game quoted somewhere within it, but yeah, so the way the examiners are doing it is they're basically grouping all your elements into one alleged abstract concept that maps to a court decision. In this case, Planet Bingo or whatever it was.
Do you remember which art unit that was in? 3600,
pretty sure. One of the 3600 art units.
Yeah, I've got a 3625 was one of the recent ones that I overcame. The invention was involved generating bidding notifications and automated bidding. And it overcame Alice, and we got over the Alice rejection, likening it to the examiner had cited Versata Development Group, which was using product group hierarchies to determine a price is an abstract idea and has no concrete or tangible form or application, and so argued against it, but. Which was not that hard given the facts of the claim, but comparing it to core wireless was what pushed the examiner over the edge, where I was comparing it to comparing the claims at issue, right, the language of my claims to the claims in core wireless and the discussion of core wireless, and it was that positive comparison of the improved user interface, the presentation of selected or limited information, and things like that the examiner was willing to look at that reasoning and the comparison and overturn the rejection. So I mean that's the thing. It's one of those issues where I know we're generally hesitant to make proactive statements, and for good reason. Yeah. But as it stands now, that seems to be one of the best ways, or one of the most effective ways to get over 101, especially when you have a recalcitrant examiner.
Yeah. So let's move on to the next step here. So the challenge of the step one analysis is the next thing. Now we're getting past the procedure. We're getting into the substantive challenge to the examiner's rejection. And this is where we have to analogize to positive cases that we've talked about before, at the ones that were decided particularly at step one, when we're talking about step one, of course.
Right.
And then we need to differentiate from the cases the examiner cites, which could be numerous. There's all as we said, there's 90 or so cases out there that they're currently citing to. And I've found that we probably, often it will help to make an amendment to show that we're directed more towards the ones that are favorable versus the ones that are unfavorable. That's what we do at step 1. So we can talk about the concept being different between the cases that the examiner is citing, or being similar to the ones that we are citing to. Or we can get as deep as looking at the claims themselves. I actually have not done this yet. I haven't found the need to actually go in to show the comparison of the claims that were at issue in each of the cases and show how they're different or the same. But I think, Tim, didn't you mention you've done this at least once?
Yeah, I've had a few allowances with discussing at the conceptual level, right?
Mm-hmm.
But the lion's share of them have been doing a deeper dive, especially where it's appropriate.
Mm-hmm.
Where we do have analogous limitations or that sort of thing. And I think part of that is that it seems to be the natural inclination of the examiners to want to see an amendment to overcome art. And I think I get the impression that a lot of them are treating it in the same way. It seems to me to be most effective to use an amendment in combination with a discussion of the concept, but then more effectively a discussion of the claims at issue.
Right. And the example that I was talking about, where the examiner determined that my claims were directed to managing a game, I had actually amended the claims during prosecution to specify that my claims were directed to presenting and terminating a user interface under certain conditions. And that was what I was claiming my claim was directed to. But the board upheld the examiner's interpretation of what my claim was directed to, which was not even tethered to the claim language. It's so ridiculous.
Right, and so this then touches on the discussion we'll have in just a minute about the question of whether and how to respond and that sort of stuff. But because like you with that examiner, that regardless of what the claim said, he was going to interpret it in one way
and be upheld by the board.
Right, and be upheld by the board, unfortunately. But I've also had examiners flat tell me in interviews that regardless of what I do, regardless of what I say, that they've determined that there is absolutely nothing patent eligible in a case. And mind you, this was a continuation case that had already had a patent issued.
Yeah,
right?
That's classic.
And so that we're gonna have those examiners until we get some hopefully clarification from the office, but more likely some clarification from Congress, and that's a big scary question as to what that would involve. But
okay, a couple tips here. The examiners sometimes cite to a non-precedential opinion, so you should always challenge that unless the facts uniquely match the facts at issue in the non-precedential decision, which almost always they do not. And if they do rely on one of those cases, that's improper according to the guidance.
Right, but understand that that's a double-edged sword, because there are sometimes that patent eligible non-precedential opinions would be a good analysis, or would be a good analogous case for you.
Right.
But unless, again, you can argue that they uniquely match the facts at issue, the examiner's probably going to summarily dismiss the argument in the same way that we can summarily dismiss theirs.
Right. So trading tech is one of the examples that comes out, but that's actually less important now that we have Core Wireless. Trading tech was a user interface case that was non-precedential that we were often citing to before Core Wireless.
Right.
Okay, so another tip is, the examiner can't just compare the claims to categories of abstract ideas. That quick reference sheet, which lists the categories, and groups the cases under the categories improperly, I would say. That is not sufficient for the examiner. The guidance says specifically they must compare the claims at issue to one or more court cases included within the categories. And I've often seen that they don't even go to that level.
Right, and Mike chimed in, and I agree. What we were talking about before, that the examiners are comfortable with amendments and claim limitations and discussing them and considering them.
True. Yeah.
So amendments number one, but then discussion and comparison of claims is oftentimes helpful. Like say, that's where I've had the lion's share of my allowances over Alice. Yeah. And with response to response templates, he says, right, and I think properly so, beware of using response templates. And I absolutely agree. The issue is when you prepare a response template, it needs to have a fair amount of customization.
Oh, definitely.
Right? So you're using it as a springboard to take that deep dive, to get rid of the perfunctory material, or the stuff that's just on the surface,
Right.
and some of that baseline language from the case and that sort of stuff. But you're using that as a springboard for a deep dive into the issues,
Right.
and a deep dive into a comparison, so that examiners are forced to engage on the issues.
Yeah, but one of the big things that's here that I noticed from Mike's comment is that really it's a question of law whether something is patentable or not, and the examiners are being asked or actually deciding a question of law right now.
Right, but the issue is we've got to, if we want to get allowances in the current atmosphere, and
yeah,
and not just allowance for allowance sake, but right for the good of the client and for the benefit of the client, if we want to zealously advocate, then we do have to meet the examiners where they are as best we can.
That's true. Yeah, and there are the underlying factual issues, and that's where the challenge over the broadest reasonable interpretation comes into play, where we are trying to get the examiner or pin the examiner down or find agreement with the examiner that there are additional elements for which evidence must now be provided under Berkheimer to support that they are routine and conventional. Otherwise, we're we're directed to patent eligible subject matter under Mayo Step 2.
Yeah, and Greg Rabin asked a question. I use a template that goes through the 4 paragraphs of the Berkheimer memo. And do you have any feedback on this approach? And I think that's the obviously that's the starting point, right?
Yeah.
Is using the memo, using the guidance, and also using the language of the cases, but going back to the discussion about Mike's comment, using it in a way that brings it back to a discussion of the claims.
Right.
Is I think often the best, and using not just rote use of templates, but use of templates that are modified explicitly.
Well, I think the Berkheimer memo, the Berkheimer guidance does set up a good the possibility of using a template that just says, first you list all the things that the examiner has labeled as being well understood, routine or conventional, and then you just paste your requirement that the examiner provide those 4 pieces of evidence. That can easily be summarized or whatever as a template type thing, and then indicate that because he hasn't provided any of these pieces of evidence, he must withdraw the rejection or provide the evidence in the next office action.
Right, and then potentially a response based on whether the response of the examiner to that argument, whether his providing that evidence or not,
right,
rises to the level of what a response to arguments should be under the impact.
Right, and we're getting to that too. First, the other substantive challenges to Mayo Step 2, and that is also like the Step 1 analysis, and that we do a comparison of court cases that are favorable under Step 2 versus the ones that are not. And Amdocs is one of the key cases that we cite, and we mentioned this before, because the court does the proper analysis according to the new Alice standard here, where it compares using common law the top cases, I guess the top few cases cited by the examiner versus the top few that were cited by the patentee in that case. And that's how the court made its decision, whether it was more like the one cited by the examiner or more like the one cited by the inventor.
Right, and not just looking at conceptually, but looking at actually the language of the claim and how they compare.
Yes.
Now the issue with this is, as we've seen from board decisions, I know you personally have had we had a long discussion about one of your recent cases, where the board is doesn't necessarily recognize an official requirement of examiners to discuss how close a case has to be to an eligible or ineligible decision in order for it to be considered like one of those and compared properly to, in order for your claims to be ineligible.
But I think Amdocs clearly shows what the law is on this matter. You have to compare and figure out which side are the cases, or which side does the invention align with. The ones that are favorable or the ones that are not favorable. And the board was saying the examiner doesn't have to do that in its decision, and that's just incorrect as a matter of law.
Right, and I agree. Now Now that's the point where right where you're rolling the dice when you go. I mean, all the time, right? But when you go to the P tab, that they may be, they may something that you clearly see as an error because the examiner is going against the guidance and against the MPEP now and against the case law. They may not necessarily determine to be examiner error, and so that's a consideration.
And also, this is another thing that we should touch upon now that you brought it up. Whether the examiner made an error, that's the wrong standard of review. The board
in this instance, right?
Well, I mean, the whole determination of patent eligibility.
Right.
It is a matter of law and therefore should be reviewed de novo. And we have some case law that backs that up even from the board that says these are de novo determinations. Yet I've seen in the appeal board decisions, the board is saying, we're not persuaded that the examiner erred. Well, that's not the issue. The issue is, did you take a fresh look with fresh eyes and determine that it fails under Mayo step 1 or step 2 and step 2?
Right, and so this is an issue. So the primary place this comes in, I think, is in the arguments, but also in the consideration as to whether to appeal, provide additional response, or abandon some situations.
Yeah, we're getting there. So I've brought this in too because I noticed in the guidance that making a separate preemption argument requires the examiner to do further work on his side because he must respond, even though it's allegedly inherent in the two-step process whether the preemption is an issue in a particular case. The examiner does have to do some extra work when you make a separate preemption argument. And also, I think it's just so valuable to demonstrate that there's not a preemption issue and in a particular case. And that's the underlying concern behind the Mayo's two-step process. I mean, if you're not preempting the subject matter, like look at my example for managing a game. If that's the area of innovation, managing a game, that's the alleged abstract concept. And I'm defining a particular user interface that's displayed as a secondary interface under particular conditions in a game and terminated under particular conditions. How much of the area of managing a game have I preempted? I've almost preempted nothing there. There's not an issue of preemption in this case. I just think it's so important to bring that up, even though a lot of people, like I'm sure, Tim, you would say, this is not really an effective argument. Right? It's not an effective argument. It doesn't win before the examiner, and I would say maybe not even before the board.
Well, I think so. So yes, I agree. It's not an effective argument. No, but in serious, I think the issue with preemption is that I think preemption is an also argument, right? So I don't think if the entirety of your argument is based on a question of whether or not you're preempting or not, I think you've got a hard row or a hard road ahead of you. Yeah. But if you can argue that not only right in the alternative, right? So my primary argument is that I'm more like this case, right?
Yeah.
And you haven't done the prima facie work to make a proper comparison to the negative case, so I should win. I think preemption also can add weight to your right. And even if all of the above, I don't even preempt, right? Because you haven't, you've done away with all the 102 and 103 rejections. So I'm not even preempting the field. What I've got is something that is tailored and that is technical solution, technical problem, and that is like these other patent eligible cases, and therefore, I should win, basically.
Yeah, and also this can be handled under the Mayo two-step process, especially think of the McRow case, which was decided at step 1, where it was almost purely, it looked like a preemption matter. And you can kind of tie that into step 1 if you'd rather do it that way.
Yeah.
Okay, so challenging the examiner's rebuttal. So we've gone through one round, let's say, of prosecution, and we've responded to the 101 rejection with all of our arguments from our toolkit. And the examiner comes back. It's time to look to see if he's done everything that the guidance says he must do when we've challenged his rejection. And the MPEP actually lists out a bunch of things that they must do to sufficiently address our rebuttal of his rejection. And so this is another thing. Again, it's a procedural tool, and it may not be that effective, but I just feel that it's something we should definitely consider during prosecution, is addressing the examiner's response to our rebuttal.
Right. And sorry, just a comment. I think here, right, that proper, and I agree with what Mike has commented, that right, generally what I try to do is especially initially, if they haven't cited a case, I want them to cite a case, because I want to discuss whether or not this is an abstract idea, right?
Mm-hmm.
And I want to say that no, this is, number one, no, it's not. Right, this is not directed to an abstract idea. This is closer to something that is patent eligible, and then in the alternative, arguing that it's substantially more, and bring in both, right, the significantly more and the technical solution, technical problem issue, and so that and forcing the examiners to challenging the examiner's rebuttal, forcing them to affirmatively state not only their argument, but I've even, to a point in examiner interviews, asking where exactly in the guidance, where exactly in the case is what they're, you're arguing this, where exactly is that in the case law and in the guidance.
I agree that the examiners do focus on step 2, but I don't think that's a reason not to argue step 1 for sure. I mean, I feel also that the rejection often doesn't delineate between the step 1 test and the step 2 test, and responses need to break it out. I mean, we need to actually separate the issues and argue them separately and really clarify what is the claim directed to, what's the abstract portion, and what's the non-abstract portion.
Right, absolutely. And I think a way you can bring in examiners to be willing to discuss with you the step 1 of the test, as opposed to just relying on step 2, is by referring to the claims and by comparing the claims.
True.
Oftentimes that'll bring an examiner into where you are, or into where you want them to be, so that you can make that the point of discussion, as opposed to just having them rely on that. Okay,
so we're getting close to the end here. We have a slide on whether to appeal, continue with prosecution, or abandon, and we have some statistics that can help us with that. Before Berkheimer and the appointment of our new USPTO director, the one-on-one rejection would doom an application to a lengthy prosecution process. So far, we have, at our firm, an 18% allowance rate and an 18% abandonment rate on these cases after Alice. The rest are still pending, I would say. Some have gone up on appeal, and we win 17% of the time on those. Our firm has a higher than average reversal rate, you can see at that blog, but still the reversal rate is not high. So that's something to consider when we're deciding how to proceed in prosecution with these cases. Luckily, Berkheimer is showing some preliminary indications that these odds are improving. So,
right, and I think the important thing, the important thing with appeal or continued prosecution, I know Kirt likes to appeal early, and I think the issue is that right, an appeal is the best way that you're going to get this, and probably the only way that you're going to get this actually in front of somebody else's eyes, right? And so if you've got an examiner that is clearly recalcitrant, just clearly not following the guidance or the rules of the case law, it's a good thing to consider, especially considerations for client and expenditures, is to say, okay, we've done our non-final and we've done our final, or we've at least done our non-final, and we've got, say, an advisory action in the non-final. So what do we want to do? If we've decided to respond to it to get an advisory action, and to say, well, we can appeal and we can kind of put this on pause to see if some of this shakes out properly, and then and then get a determination, because if the examiner's not gonna budge, and the PTAB is going to support the examiner, even when it's clearly silly, then that is information that the client then can use to determine whether they want to continue prosecution or abandon, because at least they know at that point, before they've spent $20,000-$30,000 on it, where they are and what they're likely to be getting into a long haul fight, or whether they're likely to get some movement before too long.
Right. I think appealing early is the best approach from my perspective, because you're saving the client money with potentially multiple rounds of prosecution that aren't going to get anywhere. You're able to bring out all the arguments in the toolkit. I'm going to lay out everything before the board, and I might find some traction there, whereas the examiner is not going to even consider half my arguments when I submit them to the examiner.
Right. Whereas some of those issues, and that's one of the things is when we're getting ready for appeal, is that's oftentimes where I'll take the entirety of the applicable arguments and just I've issued 30-page
yes, we've both done this.
30-page responses to the examiner prior to, just so I can have reserved everything for appeal, and so then we can take and we can figure out what we
and I'm onto the principle of the fact that these cases are being decided incorrectly. We have an examiner who's not a lawyer, not a judge, he's not a lower court, making a legal determination that my thing is not directed to patentable subject matter, which is clearly incorrect according to the court precedents, and I want to just argue that. I want to just take that to the next level and just argue it.
Right. So now we can move. I think our last thing is tips for drafting new patent applications. Yeah.
Well, we were going to mention quickly the examiner interviews.
Oh, sorry. Yeah. Go ahead.
Well, we can just use those. I think, especially when you get the first office action, you can use that first interview to try to set up the favorable delineation of the claims, where now the examiner has to show with proof that something's well understood, routine, and conventional. I mean, I think that's the way to do it at the very first stage. And also, it's a time to educate the examiner. I think a lot of times they don't understand the case law. They don't know what cases are even recently decided, like Core Wireless, for example. Yeah. And we can kind of explain, and with Berkheimer especially now.
Well, and even if they're not open to an explanation, one of the important things that interview does, and I should preface this by saying I generally don't like to do interviews unless I have to.
I know, yeah.
Because I've had examiners tell me that chainsaws were unpatentable under Alice, right?
Yes.
And so I've had nonsense in interviews.
Of course.
But the thing is they do offer an incredibly valuable thing, especially for client counseling purposes, an incredibly valuable opportunity to get into the mind of an examiner and to kind of feel out, is this an examiner that does know the guidance and that does, that does have a reason or a basis for which they're, even if they don't accurately or adequately explain it in the office action. Right. Does this examiner have a thought process behind this rejection above and beyond, well, I saw it on the quick reference sheet and that's good enough for me? Because if they do, this may be a point where this is an examiner that you can work with, even if the initial rejections are not, are not promising.
That's true.
But if you've got a point where you've got an examiner saying, I will not allow a patent, I see nothing patentable in this thing, period, or patent eligible in this period, then that's a talking point to go into your client and to give them a realistic expectation of what this is going to take, and so they can make an informed decision. And if nothing else, even if they choose to abandon that case, the fact that you've gone in and done that counseling and you've gone in and done that investigation is providing them the benefit, providing them that that benefit of your counseling expertise. And so it's a value add proposition, even in cases where they've decided to abandon for possibly other reasons.
And speaking of abandonment, just one more point here is that I have never recommended abandonment over a one-on-one issue. I just don't think that I've ever seen a case that's so abstract and has nothing significantly more, or couldn't transform, or no transformative elements. I've never seen that, in my view. So I would never recommend it.
I've recommended abandonment, but I've recommended abandonment not purely for the one-on-one issue. I've presented it as an option. I shouldn't say I've recommended abandonment, but I've presented it as an option to say, look, is this economically viable? Do you want to spend this money? Because if you do, we can, right? And I'm more than willing, to give it a good faith effort, and we may get something out of it. But if they're not in a position to spend that money and to take that time to do it, then it is a business decision for them to make. And so I've offered it as a viable option in those cases.
Right. But I just don't want to concede that anything is patent ineligible. That's ridiculous.
Okay. Oh, yeah.
Moved on to tips. Last one, tips for drafting new patent applications. This is only one slide, pretty quick. Obviously under Berkheimer, don't concede. Oh, go ahead, Tim.
Sorry. I was just going to say we've got a couple of questions.
Yeah.
The last slide has our email and contact information.
Okay. Yeah.
Just just in case, if you want to contact us and discuss further or have questions or whatever. So just and we'll be sending out a link or the presentation materials as well as the recording, right?
Yeah, we're well over the scheduled hour here. So
yeah. So it's understandable that people have to go.
Tips for drafting new patent applications: don't concede that anything is well understood, routine, or conventional. That's the most obvious one for Berkheimer, obviously.
Yeah.
The examiner can actually use that as one of the pieces of evidence if you've conceded in your specification that something is well understood, routine, or conventional. So obviously we don't want to give them any ammunition.
Right, and there's ways to prevent that idea that something, in order to flesh out your technical solution, or to a technical problem aspect, there are ways to flesh out or ways to discuss that of what previous systems may have done or previous systems attempts to do something without conceding that, that a concept is necessarily well understood, routine, and conventional.
Yep. Okay, so provide specific examples of applications of any formulas or algorithms. So I've had examples where I've gotten a white paper from an inventor and it's got a lot of mathematical calculations and formulas and so on. Part of my job then becomes figuring out in the disclosure what are the applications of these formulas and describing them, maybe paragraph after paragraph with a different heading or whatever, different applications of how each one is used.
Right. Well, and that way also when you have that formula in there, as odd as it is to say, I've been able to use that to differentiate my claims from the formula itself. Right. To be able to say, look, okay, here is the formula, and this is more than just a prose version of the steps of the elements of the formula.
Yeah.
Right. So we're doing above and beyond the formula. So it can be a fallback position, essentially.
Right. So Amdocs talks about technological solution to a technological problem. That's something you can set up maybe in your background, what the problem is, and then get at a high level describe the solution. Not in the background, obviously, but in your detailed description, you would describe the solution to that problem that you set up. But that's also an issue. I've always said the backgrounds should have almost nothing in it. So you can find the technological solution to the technical problem to the detailed description and get into it there, but at least describe it that way so that you've set it up that way.
Right, and I think this is an important thing with EPO practice. This kind of parallels and integrates into EPO practice. And I think the important thing to look at here is I know that for a long time best practice was or a lot of people consider best practice to not include that sort of a problem solution statement because of the potential for it to be limited in litigation. But you have to have a patent to get into that stage of litigation to begin with, and if that's what keeps you from getting a patent, then that's a questionable strategy. And so similar to the EPO, but I think it's not just generally the technical solution to a technical problem, but it's making sure you have a depth to your technical solution where you're referencing multiple different embodiments or multiple different claims.
Right, such that you can make an amendment later where you can clearly tie, as in Berkheimer, the amendment, or any new language to the claim or the claim itself, actually originally as it's presented, to that technical solution to that technical problem. Because you can look at Berkheimer's decision and they've actually decided that the claims that weren't tied to that solution were unpatentable, whereas the ones that were tied to what was described as an improvement in the specification were patentable. That there was a disputed issue of fact regarding
Right. And as an example of that, I've seen examiners where I did have a problem solution statement and a fairly technical one in an application. I have seen examiners try to argue that the technical solution that was described in the application was limited to certain embodiments or certain claim language, and therefore if we're adding in other ones, then that wasn't a technical solution to the problem that we're talking about. And so the idea of this kind of intermittent levels or differing levels of inclusion and reference to that as a solution to the problem can help, as well as mirroring elements or mirroring language in different places in your application. So not only in, say, an initial portion, but also in part of the, the flowchart discussion and part of the, say, even if you use stock paragraphs or partially stock paragraphs for your, system and computing environment sort of things, is to incorporate some of that in there so that you're weaving together these sections better, so that they can't summarily dismiss certain arguments that you may need to rely on later on.
Yep. Describe a specific user interface. This is pretty obvious in view of core wireless and trading technologies, which is that non-presidential case before it. I think that this is important, like say in the disclosure meeting, to ask the inventor, how are you going to display that? Or how are you going to present that data you're generating on the back end? Or is there anything unique about what's happening on the client side that in presenting the information that we should describe? Things like this to flesh out maybe a specific user interface along the lines of core wireless, which was that application summary window. That was all that was needed to be directed to patentable subject matter under step 1.
Exactly. So even if the inventors can't provide you necessarily with a screenshot, if you can mock one up based on their explanation of interactions or of modifications to the way this system is used, then it's a concrete example. And I think that's the important thing, is a lot of this boils down to concrete examples of being able to point an examiner or a judge or whomever to something that they can say, oh, I see what you're talking about, and I see that is neat or useful, or I've seen something like that before. And so then they can engage in that in more than a theoretical exercise. They can latch onto it. And oftentimes that is, that has been, or a number of times that's been seems to be the saving grace that got over a rejection.
Describe improvements in computer functionality, where we talk about usage of processing power, memory, bandwidth, and so on. This seems to be something the examiners are always looking for in the spec. And if we can just put those in there, like for example, let's say you have a search technology that you've got an improved search technique or something like this. I would argue that the fact that less searches are now needed to be processed on the back end because they're more accurate, maybe the search is more accurate for the end user, there's less processing needed on the back end. And so you've improved the usage of the system. Now less processing power memory is needed.
Right, and this stuff is, these things are easy to integrate into the technical solution aspect. So whenever you're saying here is a technical problem, not necessarily the only one, but an example of, or one or two examples of technical problems that the present application or the present subject matter solves, and then here are some of the ways that they solve them, and here's some of the evidence that we're solving these, or here's some of the benefits, ancillary or direct benefits that we're seeing. Is it's easy to wind that in just to kind of flesh out that technical solution, technical problem statement, but it has been useful. And I've had examiners specifically tell me that if I can find anything in the specification that references that sort of stuff, and that's going to be a not necessarily the determinative factor, but that's going to be something that'll push them over the edge if necessary.
Yep, exactly. Describe importance of distribution of components. Remember in Bascom, the fact that the rules were on the client side versus on the server side versus the client side. That was all that was needed under step 2 to render that patent eligible.
Right. So, now it's important to differentiate this between electric power, where they've got a distribution of sensors and then they're bringing it all into the central location and doing it there. So it's a centralization instead of a necessity to have distributed components in order to solve certain issues.
Right. I guess the takeaway is maybe be a little more detailed if possible in some of the architecture diagrams and things about where things live in the architecture.
Right, especially if there's a benefit for them to live in one or more places.
Exactly, yep. And describe that benefit.
Right.
Describe particular combinations of components as unconventional. So when you deal with the step 2 analysis, you want to be able to point to something where you've declared maybe that something is unconventional. Whether it is or not may be debatable, but at least you've made that initial declaration that, look, this stuff is a combination, whether generic stuff maybe, but it's a combination that's unconventional. And then the final step is update the boilerplate. Many of our cases will have a general or mention or describe general purpose computers, and I think these should be rephrased as special purpose computers. What you have is a computer with a memory that has new instructions. It's configuring the system to do whatever you've described in the specification. So,
right, and this is kind of a basis to say that your or kind of an ancillary support for the concept that you're changing the tool instead of just the use of the tool.
Yeah.
And so you know, I mean, some of this stuff is little things, but the little things can eventually add up. You know, we've seen from examiners, the little things can add up to be something that moves the needle enough to get you over an Alice rejection.
Yep. All right, we've reached the end. We did it.
And 30 minutes over. So thank you for everybody who stayed. I mean, I know it's super long, and we appreciate the engagement. Are there any last questions? Anything? Any thoughts or questions? Things you want to share?
Hey, thanks, Kirt and Joe, or Kirt and Tim. Yeah.
Rough.
Yeah. Sorry. I'll send along a recording once I get it posted, and the slide deck as well to everyone with Tim and Kirt's email information and contact information. So if anyone has any questions offline, you can feel free to contact Kirt and Tim directly. Other than that, thanks for everyone for joining. And Tim and Kirt, thanks for taking the time today. This is an awesome presentation.
Thank you. We appreciate it.
Thank you. Yep.
Cheers, guys.
Bye, everybody. Thank you.